Hello everyone, so I'm George from Ireland. Welcome back to my English law channel. Anyway, so we're looking at the law of property, or land law as it's often colloquially known, and now going to look at the role of formalities, because buying and selling matters, obviously, buying and selling land, forgive me, my mind runs ahead of my mouth, is a serious matter. So we have to be clear as what has been bought and what has been sold. It can't just be a verbal agreement. So there are all sorts of interests in property, which I adumbrated in my last session, and the acquirement of these is not simply by taking possession, but it's also by some title deeds being exchanged, conveyancing. In most cases, the legal and equitable interest in land are acquired derivatively, and this happens when you transfer an extant interest, for instance, fee simple, the leaseholder, the mortgagee, etc., and so forth. They transfer this interest to another person, or it could be by granting a subsidiary interest which is taken out of an extant interest. For instance, supposing the fee simple owner grants someone a lease, or indeed an easement, or a restrictive covenant, something like that, or the leasee, that means the one who already is the leaseholder, gives a sublease to somebody else. So this is called derivative acquisition, and it usually happens purposefully, and it could be a gift, it could be a bargain. Bargain as in there's some negotiation, something is paid for it. It could be a payment which is pecuniary in nature, or it could be exchange of land or goods. However, that's not always the case. There are things called non-express easements, but I'll come back to those later. Okay, so it's sensible for the law to say that you must fulfill certain requirements. These are formalities, so we know exactly what the parties intended. We can be sure about that, and the parties will take this seriously to know this is irreversible. If you change your mind about it, no, you can't get it back. It's done. So we can be sure who owns what. Lon Fuller was a celebrated scholar of jurisprudence, and he said this is about channeling people down certain prescribed routes. So then the law can understand what the situation is, because it was all in confusion. It'd be terribly difficult for us. We wouldn't know who owned what. I've seen places like Romania in the 1940s. There was a lot of land was nationalized. Over 50 years later, people trying to get it back, often the grandchildren of the original owners, and who owned what, and the whole situation was in flux. It wasn't sorted out for decades. So, so bear in mind, these formalities, they might be a source of injustice. The formalities could have one party relying to his detriment upon an oral statement, which is therefore unenforceable, or a declaration of trust, which is about land. Now, in situations like that, equity will usually intervene. We don't want too much intervention, because that would defeat the doctrine of formality. Remember, a proprietary estoppel is here. You will have studied contract law before you come on to property law, and there's a reason for that, because there's certain foundational principles you need to grasp before you can comprehend land law. So they're going to look at formalities more and more as we go on. And this is a contract is not the same as a conveyance. We're looking at land transactions. A contract is someone agreeing to transfer his or her interest to another person. And for the most part, that's before the transfer. The transfer itself is the conveyance. I'm conveying to you. Conveyance can often mean something like a car. So moving something from one place to another, or in this case, the interest from one person to another. Okay, so land transactions are not just simply about buying and selling land. They can involve other things as well. We usually see this exchange of contracts, and then the second stage is known as completion. All right, there are different formalities which are applicable. So with there's a bilateral instrument that says that yes, we have an agreement. And then the second stage, the transferal stage, completion, is a unilateral contract where that's mean the transfer actually takes place. The ownership of the land is handed over. So there's this requirement as per Section 2 of the Law of Property Act, Miscellaneous Provisions 1989. means several laws of property acts. So you've got to say which iteration you're talking about, like 1925, 1989, 2002. There are others. If there's a contract to transfer legal or equitable interest in land, it must be in writing. It can't be simply a spoken agreement. And this agreement should contain all the terms and must be signed by both parties thereto. So there's a thing called estate contract, and that's an equitable interest, and it binds the land. That means the person who owns the land or has the other interest in land is engaging in a formal contract with somebody else to transfer that interest in land from the first person to the second person. And this can be binding upon a third party, as in someone who was not actually signed up to the contract. For instance, if Alfred contracts to sell the land to Ben, and then Ben sells it to Charlie, Ben has an equitable right which could bind Charlie. So under these conditions, it allows Ben to oblige Charlie to convey the land to Ben under the terms of the original estate contract, which Alfred was bound to Ben. So look at Scott and Southern Pacific Mortgages Limited 2014. This went all the way to the British Supreme Court, and the court found that a specifically enforceable contract to grant an estate does not give the intended purchaser a proprietary right in the estate. That means if they had that, they'd be able to take a subsidiary interest for the benefit of third parties. They only had an equitable right, and that was to require specific performance of the contract against other people in who the title and the estate was vested. Okay, so I'll come back to that later. That's a lot to absorb for the moment.